From the Australian Institute of Company Directors, and I pay compliments to the organisers of this conference. I think it's been a fantastic event so far. I fully endorse all that Chris has said so far, that regulation, and there was a comment earlier on today as well, that regulation is not sufficient in itself, is not a sufficient condition, but it can complement sound corporate governance. Let me start with a quote. I love quotes, and I think this one really helps position where companies are. It's by Nicholas Butler, and I think if he made the comment, this quote was made in 1911, if the quote was made today, I'm sure Nicholas would have included the internet and the computer chip, as well as steam and electricity. The corporate model has become the pervasive model for business endeavour, and has become the pervasive model for social infrastructure ownership and service delivery. Corporations, as Ram mentioned, are virtual corporations designed to deliver economic outcomes for the betterment of society. And through legislation and regulation, and through some less formal means of control, they're conferred a statutory licence to operate, with the general acceptance that the miracle of the limited liability corporation has delivered profound benefits to mankind and its standard of living for some number of years. And equally, power is with society also to control and temper that mandate through regulation, through legislation, and through some less formal means of influence and control in the marketplace. And so to control those activities, and also to control those entrusted with their management and control, i.e. their directors. My proposition is that spawning from this significant growth and influence of the limited liability corporation and major corporations, questions are being asked as to the legitimacy of their roles in society, and efforts to curb their corporate conduct, including through a plethora of prescriptive and unprincipled regulations and oversight, so as often to satisfy populist concern that there should be a law about this because someone has been dissatisfied, some vocal minority group. Furthermore, many of these regulatory constraints are unnecessarily penal in nature and tend to be directed more against the directors and officers than the corporation itself. So if we're looking at contemporary best practice around risk analysis and mitigation under ISO 31000 series, we start thinking in terms of identifying risks, of the cause of the risk to be determined, and we then look at the impact of the risk and the means of treatment of that risk as well. And then we move through to analysing each different risk and its cause, including in the context of the impact significance and also the likelihood of occurrence. The same principles should be applied when we're thinking about regulation to control corporate endeavour. So what are some of these risks? And I think there are four main risks we're talking about. We're talking about agency risk for investors. We're talking about solvency risk, the going concern concept. We're talking about community risk, the ESG sorts of issues, and we're talking about dependency risk, as we touched on this morning with the banking system, utilities and so forth, where society becomes very dependent on particular aspects. And I think when we look at the causes of these, we can analyse another number of issues. Some are due to impropriety. Some of these risks are caused by mere negligence. Some are just mere underperformance relative to other corporations in the marketplace. There are some which are inherent business risks or economic failure causes, environmental or social causes beyond the reasonable control of anybody, failing to adapt to changes in society's mores from time to time, failing to keep up to technology advancements, systemic failures of accepted economic or social models, or shortcomings in effective public policy. So each risk needs to be considered, the cause needs to be considered of those risks, and the appropriate treatment means needs to be considered as well. And one size or one solution definitely does not fit all. And regulation is certainly by no means the only treatment means that we have available to us. There are many less formal powers within society to influence some of these risks. Social media is becoming a very powerful force in this respect. However, even if regulation and the treatment of the risk and its cause is warranted, then that regulation needs to be appropriately crafted so as to be fit for the intended purpose. So I'm saying our social justice system is premised on principles of personal liberty and due process, and those principles need to be jealously guarded and should only be compromised in appropriate circumstances. Now, what are we talking about here? We're talking about, if it's principled, then it must satisfy all of these criteria that I have on the board here. The behaviour must be prescribed, to be prescribed or proscribed, must be essential for the orderly conduct of society or the sustainability of its functionality. There should not be an effective system already in place, or we have got an existing system and there is a market failure. There needs to be fairness and equity in the regulation, in the context of the mischief to be addressed and the benefit to be derived. There needs to be reasonable prospect of it being enforced, and there needs to be regulatory efficiency. Now, if regulation is appropriate, then the regulator has a number of tools available at his disposal. However, many of these tools, and I've listed quite a few of them there, I think unfortunately there is a tendency for regulators to resort to that final one, the offences and the enforcement, the retribution and the deterrence, rather than some of the earlier ones. The big stick approach, thou shalt not do this, or thou shalt be punished, and ignore many of the other tools which are otherwise available. So I think regulators do need to use the most appropriate tool in their toolbox for the job at hand, rather than relying on retribution, deterrence and punishment, which can tend to be reasonably blunt instruments. So we have an evolving, some of these principles pose challenges to our regulators, and certainly in Australia we're seeing some rather evolving unprincipled regulatory practices by our regulators. First of all, the creating derivative or of fact deemed offences by directors. They become liable by virtue of their office, not necessarily by reason of anything that they have done or that they reasonably could have done by holding the office that they do hold, particularly applying to non-executive directors. We're seeing pernicious penalties for civil offences with lower prosecutorial burdens than you'd normally apply for criminal offences, notwithstanding that the penalties are quite profound, including extraordinarily high fines and banning orders from practice of directorship. We're seeing the reversal of the presumption of innocence or the burden of proof, with a deemed liability unless the director can prove their innocence in accordance with some vague defence that might be available to them. In some cases, in occupational health and safety in Australia, we're seeing prosecutorial powers vested in the hands of special interest groups, e.g. trade unions. We're seeing non-judicial executive infringement notices, sort of like the speeding ticket being issued on the spot in a corporate setting. And we're seeing coercive information gathering powers by regulators with criminal penalties for failure to apply. And I suggest that these practices need careful review. And in Australia, we think we live in a free state. We must get the regulation right. And there needs to be a case for intervention, must be established. All alternatives should be properly considered. The cost to business needs to be calculated. There needs to be effective shareholder consultation before regulation is introduced. There needs to be adequate regulatory impact statement, and there needs to be some post-implementation reviews undertaken as well. I love the quote at the foot of this particular slide. It's from Edward, the first Baron of Thurlow, back in the 1700s. Did you ever expect a corporation to have a conscience when it has no soul to be damned and no body to be kicked? Well, directors are the hearts and minds of corporation, as Mervyn King reminded us yesterday or this morning, and executives are the arms and legs of those corporations. And so society seeks retribution in the case of corporate failure or fault in the form of a soul to damn and a body to kick, and in directors, they have found their target. Limited liability in the context of a corporation is a shareholder right, not a right of directors. So there is a case for regulatory reform, and in particular, there is also an urgent need for a universal and uniform protective business judgment rule, a BJR, where the director has acted reasonably in all the circumstances, has acted honestly and in good faith, and held a rational belief in the decision was in the best interests of the corporation. And without such a principled and appropriate regulatory approach, and without that effective BJR protection, I believe society bears the risk of certain adverse unintended consequences arising, and the risk doesn't just fall upon the corporation and its directors. So what are some of these unintended consequences? Well, these arise because for society, because corporations and their directors will move to seek to avert or avoid the consequences of unprincipled regulatory intervention, so as to avoid the corporate office by capable people, to avoid personal liability and reputational risk, and these are probably some of the people we actually need as leaders of our corporations. We're seeing unwarranted distraction from constructive enterprise value creation, with undue focus on the tick-the-box compliance, which stifles innovative governance improvement and corporate performance. We're seeing cost and efficiency burdens to the detriment of shareholders and the general community and economy. And we're seeing the insidious effect of regulatory compliance being a sufficient condition, and this was touched on earlier on today, without regard as to what may be done, what should be done, or what is right to be done. And importantly, this includes the risk of loss of international and strategic competitiveness. So to conclude, I believe that there is a proper role for regulatory intervention in appropriate cases to reasonably and properly hold corporate directors and officers to account. Where regulation is appropriate, it needs to be principled. And there is compelling argument to review some existing unprincipled regulatory approaches and practices that have evolved, which I believe are offensive to the rule of law, which underpins our social system of justice. And unless balance can be found, it's society which will bear the risk of unintended consequences, including the loss of international and strategic competitiveness, and they will also risk loss of the bounty that would otherwise flow to society from the miracle of the limited liability corporation. I thank you for your attention.